What is the difference between probation and parole? Attorney Donald Beebe says, probation means that the person who is convicted of a crime is assigned to a probation officer, and the judge usually imposes conditions of probation. Those conditions always include that the convicted person cannot be arrested for another crime, and usually relates to the events of the arrest or the events that led up to the arrest. In other words, if a person was intoxicated or was under the influence of drugs at the time of the offense that led to the criminal conduct, the judge may impose drug and alcohol counseling and then treatment. Another condition for probation, for example, in a larceny case, the judge may order that the convicted person pay the person from whom the money was stolen. This is also true if there was damage to property. They may be ordered to make restitution for property damage. If a person was injured by the convicted person, he may be ordered to pay medical expenses. These are just some examples. Parole is when it is decided by a parole board to reduce the time that the convicted person is actually in prison, and he or she can finish their sentence on parole. The person is supervised by a parole officer. When you are on probation, you do not need to go back to prison unless you violate the probation. You are entitled to a hearing before a judge to see whether or not the state can prove that you have violated the conditions of your probation by the fair preponderance of the evidence. In a parole situation, you stay out in the community as long as you do not violate the conditions of your parole. But once the conditions are violated, you go back to prison. There is very little review of those decisions. For a free phone consultation, contact Attorney Donald Beebe in Norwich, Connecticut at 860-889-5266 or visit his website at www.beebeandoneil.com.